Good evening. My name is Fred Goodwin. I serve as the secretary to the Zoning Board of Adjustments. We have a little bit of an unusual situation tonight. Both the chairman and the vice chairman have been unable to attend tonight. So we will be conducting a special election to elect a chairman pro tem who will preside over tonight's meeting, just for this meeting, and then next month the chairman and vice chairman will resume their duties. But having said that, I'm going to go ahead and open this meeting and call the roll. So, all right. Mr. Wortley. Here. Mr. Alsabrook. Here. Mr. Perkle. Here. Ms. Hand. Mr. Foley. Mr. Roberts.
Here.
And Mr. Gear.
Here.
All right, thank you. All right, as I indicated earlier, we'll go ahead as one of the first items of business is to conduct a special election to elect a chairman pro tem for tonight's meeting. So having said that, is there a nomination for that position?
I nominate Stuart Roberts for chair pro tem for this term.
I second that.
All right, thank you. All right, any other nominations? All right. Mr. Roberts, would you consent then to serve tonight?
I will consent.
All right.
Thank you.
Since it's the consensus of the board to elect Mr. Roberts as chairman, we'll approve that by acclamation, and I'll turn it over to you.
Okay, thank you, Mr. Goodwin. I'll call to roll the March 3rd, 2022 meeting of the Homewood Board of Zoning Adjustments. We'll start out with, first of all, I'd like to acknowledge Mr. Alsabrook, Scott Alsabrook, who is the new member of this board from Ward 2, I believe? Yes. Okay. Can't believe I got that right. Anyway, we look forward to serving with you. We thank you for your service to the city, and hopefully this will be a fun, rewarding experience for you. So, all right. So I think earlier today, Fred circulated some minutes from the February meeting. Did everyone have a chance to review those? I didn't have a chance, but if you guys did, we can think about approving those. All right. I'll entertain a motion to approve those.
I move we approve the minutes from the February 3rd, 2022 meeting.
Second that. Okay, all in favor?
Aye.
Okay, moving along. Communications from the chair and vice chair. We can skip through that part and then move on to new business. Before I do that, I wanted to mention on the agenda tonight is the fifth case, SV 22-03-05, was an application relating to 920 Palmetto Street. That has been pulled from the agenda. I think it'll be carried over to next month. So if you were here to speak on that case, that's not going to be heard this evening. Okay, let's start with new business. The first case is SV 22-03-01, relates to 1516 Roseland Drive. The applicant is Twin Construction. If you come forward and state your name and enter it there on the pad thing.
Yes, my name is William Siegel. I'm with Twin Construction. I live at 1707 Shades Park Drive in Homewood. We are looking to add a rear addition on this home. The lot is actually 8 or 9 feet wide. Because it's over 55 feet, the setbacks are 10 and 10. The existing left side of the home is existing non-conforming, and we're asking to extend that straight back. We will be 6 foot off that property line on the left side, so we are requesting a 4 foot variance to the 10 foot setback. I do have a letter that I just received today from the neighbor on the affected side on the left. If y'all want it, just stating that they're good with the addition as.
It'd be great. Thank you.
Yes. You got a copy now?
Okay. Yeah, thank you.
Anything further, Mr. Siegel?
No. I'd be
Okay.
happy to answer any questions or concerns.
Sure. This is a public hearing. If you're here in the audience today and you want to speak to this case, this is your opportunity to come forward. Okay, seeing no one, we'll close the public portion of this hearing, and Mr. Siegel, if you would answer any questions that this board has.
Be happy to.
And just for, I think for all of our benefit, you mentioned that this lot is just slightly over 55 feet, which resulted in the 10-foot setbacks on both sides.
Correct.
If it had been 54.9 feet, you would have 5 and 9 on the
Yeah,
two
been a
sides.
couple inches narrower. It would have been a 5-foot left side and 10-foot right side, correct.
Okay, and the other thing, I guess other question I had, and I think from looking at the drawings, I got this, but the previous, the existing condition on the left side, it's 6.6 feet off the property line. After construction, if this is passed, it would be 6 feet. Is that based on just the lot line? Are you building straight back, or is there?
I'm building straight back. There's an angle to the existing structure that skews me about 6 or 7 inches over the length of the addition. So if you were to add on to the left side of the house and go straight back, technically I'll get 6 or 7 inches closer to the property line.
Okay.
Due to the existing nature of the orientation of the house. I will say, I mean, if the 7 inches is an issue, there is a way that you could step part of it back to remain 6 foot 7 inches, and I can make that proffer. I just didn't see the difference between 6 foot and 6 foot 7 inches, so this is our request to keep it straight.
Mr. Chair, may I ask a question?
Absolutely.
Have you done a structure takeoff yet? From the
for the-
drawing that I just got, the revised drawing?
For impervious,
For structures, 50% in front and 50% total. And that doesn't have anything to do with what we're here.
yeah, and
tonight.
we can
That's just-
address that,
Right.
but it does meet the 50%.
Okay.
It meets the 30% rear yard, and what was the third thing you mentioned, the 50%?
Front yard.
Front yard, that's something we'll have to calculate
Okay.
too. They had added a parking pad. I know we will have to do on-site engineer
Okay.
retain it,
All right.
retaining the water and all that stuff, and so we've got that
Great.
noted. But
Those are all items that would have to be addressed before
that would be,
permits issue.
and trees, and yes, we have trees too. But all that'll get addressed as part of the permit process. We're getting better at that.
Overhang on the, plan west side.
I think code allows for 18 inches. I believe it's just a 6-inch. In fact, I may have a elevation on here I could look at. It's not it's probably 6 inches. It's just a standard closed soffit. And that's just to match up the existing house. There's no additional overhang.
Gentlemen, if there are no more questions, I'd entertain a motion.
Move that we vote on case number SV 22-03-01. I second that.
Call the roll,
All right.
please.
Mr. Whitley?
We're voting to approve, right?
Yes.
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 Yes. Mr. Alsabrook?
Approved.
Mr. Perkel?
Yes.
Mr. Gear?
Yes.
And Mr. Roberts?
Yes, so your passes 5-0. You'll have, I think it's still 180 days to pull the permit. Might be still 180, okay. 180 days. Thank you.
Correct.
Okay, I figure there's a reason you're still standing
I'm
there.
staying.
So our next case is SV 22-03-02. The applicant is Twin Construction. This relates to 29, I'm sorry, no, that's the, sorry, this relates to 1506 Valley Place. As you've already signed in and already stated your name, you can go ahead and proceed
Okay,
with
great.
respect to this case.
This house has an existing carport and storage area on the rear of the home. Due to the setback requirements at the time that we built this years ago, it was a 5-foot left side setback. The house, the structure now is actually existing non-conforming because it is over 15 feet tall existing. It's actually currently 21 feet tall. We are requesting to add 4 feet to the height there, which would require a 10-foot left side setback. So all in all, we're taking the roof line, we're raising it up 4 feet so that they can use it for an exercise room above the existing carport. We're going to be 5 foot from the property line because that's the existing structure right now. So we're required, because the height is at 25 feet, to request a left side property setback from the 10 feet to the 5 feet. So the net difference on height is 4 feet. The other thing I'd like to say is the left side, the side closest to the property line, will have no windows on there. It'll just be a 5-foot knee wall. So basically, we're taking a 0 knee wall, we're raising it up about 4 feet so that we can get that. And that's shown in the elevation drawing. Hopefully, you've got kind of the existing and proposed. So the proportions of the house, or the structure, I should say, are similar, just, again, raised up slightly. So that is the request for the left side setback on the accessory structure.
Okay, this, again, is a public hearing. If anyone wants to come speak to this case, this is your time to do so. Okay, and seeing none, we'll close the public portion, and if you'd answer any questions this board has.
I would be happy to.
And I know this is in the application itself, and he just mentioned a moment ago. Is it, Fred, can we ask that there be a proffer that no windows will go, and that be part of the approval?
I can proffer that.
He
can
would
proffer that.
consent.
I'd be happy to proffer that no windows will be on the left side of the structure, which technically would be the west side.
What is the height limitation?
For accessory structure, is it 25 feet? Yeah.
My understanding is that depending on the height, the setback has changed, and that recently changed so that something, even the 21-foot structure that's there now would technically now, if it was built as a new structure, would have a 10-foot setback.
10 and 10.
Yeah, it's existing non-conforming as it says.
I can't tell this, the property to, I guess that would be the property to the west that's on the alley there, that is kind of a, I don't know what shape that is, a rhombus or something, I don't know. Which way is that house oriented toward Valley, or is it?
Yes, sir.
Okay.
It's oriented south towards Valley.
Okay.
The alley is actually a paper alley. There's no true alley back
Oh,
there.
okay. I didn't, I lived on Grove Place, I don't remember there being.
Yeah, it's just,
An alley
I
going that
think
way.
it's mainly utility easement more than anything else.
There's an alley that you can access off of Hawthorne, but it's actually 126 East Hawthorne. He uses it as a driveway.
Yeah, technically, the guy on Valley to the left uses the alley as the driveway too.
Right,
so-
right.
But it does not go to the
It
rear.
doesn't run behind.
No,
It's
right,
not
doesn't run behind.
An accessible alley.
Correct.
And looking again at that next door, now that I see that house at 1504, the corner shape of that back corner shot, on the north side of that lot, northeast side of that lot, looks like there's not really a risk to be a similar type structure built there.
No, it's not really
kind of a-
accessible to the structure.
Gentlemen, any other questions?
Yeah, I guess I'd like to ask staff, I see here that the analysis revealed that the applicants failed to establish a hardship on which to base approval. Is that just because of the nature of the documentation, or?
You're asking what hardship is?
Yes.
That would be up to them.
Yeah. So the hardship is stated as existing non-conforming carport. So the carport, as it sits, is non-conforming. Since we're looking to save the structure and go up, we're asking that the non-conforming existing structure be.
Okay, and it's non-conforming because the code has changed?
Yeah, the code now says that the structure is non-conforming, correct?
Do you have a copy of the staff report?
Yeah. Yeah, I'm trying to.
Page 3 of the staff report suggests, right under the photo, we don't know if the 21-foot high structure was conformed at the time it was built.
I do not know.
Okay.
Do you recall when that was built? I think you said
16.
Yeah.
16.
That sounds right.
Okay.
Yeah.
I know we changed that setback requirement not too
It
long
may have been
ago.
enforcement, but.
Sometime between 16 and 19, because I don't know when that was changed. I just know that there was not a variance for it.
Honestly, it's been changed multiple times over those years. It used to be accessory, and then they made you line it up with the setbacks of the structure of the house, and then it went back to accessory, and that's all, predating when these guys were here.
Move we vote on case number SV 22-03-02. Second that.
All right. Mr. Wortley,
Yes.
Mr. Alsabrook,
Yes.
Mr. Perkel,
Yes.
Mr. Gear,
Yes.
and Mr. Roberts.
Yes, so your case passes 5-0, again, 180 days to pull your permit.
Thank you for your time.
Okay, our next case is SV 22-03-03. It pertains to 2916 Linden Avenue. The applicant is Strassner Investment Company. If whoever's presenting for this case, come forward now to tell us what you are asking us to do.
How are y'all doing again? Hopefully this will be the last one we have to do for y'all. I am Chase Strassner. I live at 506 Dexter Avenue in Mountain Brook. And I believe there are two different requests there. One is to change the amount of parking spots that we need from 7 to 5, which the space currently has. And the other would be to allow parking spaces to be actually pulled into and backed out of on a main street. We would actually prefer limiting the spaces to 5. The groundwater retention, I don't think we would be able to pass that, putting in 2 more spots in the back. But would like to answer any of y'all's questions that y'all might have. And just to say, I don't think the lot, from what I'm told, is actually, from the 5 spots that are grandfathered in on the front of the building, I don't think you're technically allowed to even put the lot isn't subject to add any spots to meet code, being an old residential lot turned commercial.
Would you-
Be able to put not being able to put a parking spot?
I understand the concept of not being able to put a parking spot somewhere, but you're saying that it's not legal?
So, from what the code is, you can't pull out of or back, so we're sandwiched in between 2 alleys.
Yeah.
So the 5 that are there are grandfather illegal.
Yeah.
And then if we were to add any, we would have to get a variance.
Right.
So, and Sherry, maybe I'm missing something, but the application, the way I read it, is simply relating to the number of spots, requesting a variance
When
to
I
allow.
reviewed it, the code does say that only from a residential lot can you back onto a public street. And so we felt that since the code does say that was the variance that he needed for these 5 spaces on the front. In addition to his request to reduce the requirement from 7 to 5. I would suggest that, you split this and let them vote on these 2 items separately.
Of course.
Just for the benefit of the board,
Yes.
this piece of property was successfully rezoned by the city council from an office use to a retail use. So the intended use from this point forward is that it would be a retail use,
Okay.
just to let you know.
That will not change the number of
No,
requirements.
no, it still needs the 7.
Okay. All right, before we ask you any questions, Mr. Straisner, we're going to open this up to the public. It's a public hearing. If you want to speak to this case, please come forward now. Okay, and seeing no one, we'll close the public portion and address any questions we have to you about this.
I wanted to ask the question, as far as the parking spots in the back, the potential for that, is there any future use of that besides possible parking or landscaping?
Probably putting a dumpster out there, but besides that, there would be really no use. And which the surrounding area, and it's pretty easy to see, people take advantage of it. So if it's open area, people are gonna probably end up, which we can't control that, and people will probably end up pulling back there to park, which is kind of what's happening everywhere.
And staff, I would like just to ask, in the event that the variance is not approved, to reduce the 2 spaces, how does that work with the planning of this retail space?
I believe they would have to reconsider the use of that back portion,
Okay.
to see if there was a way to put put a couple of spaces back there.
Thank you.
So there's no proposed spaces off the back alley?
Correct.
Okay. That's because, why?
Well, originally, we had put in our plans to have spaces back, actually 5 spaces, and then it was rejected saying that, variances. And then way down the road, about 2 months after submitting everything, we got, told that we actually need 7 spaces. So it was kind of, we were so far along the process, and then we, got told that we actually needed to bump it up to 7.
So again, the question was, do you envision being able to put, if you needed to, could you put 2 spaces in the rear?
Oh, yes, we definitely could, just as long as it would meet the water retention. But yes, that would be ideal.
Can you explain that, the water retention?
Groundwater retention, you've got to have so much natural ground for water runoff to seep back into the soil.
So it's gotta be pervious?
Yeah, yes.
So I'll jump in here real quick. Those aren't entirely true.
Okay.
It's close, but, I mean, they can manage their stormwater with underground detention, and they could do that under asphalt, connecting to to our storm infrastructure. Does that make sense? So they don't necessarily have to have like grass or bioswales or anything like that in the back. They can manage their stormwater through other measures.
Okay.
I did not know that, thank you, Cal.
Yeah. He will still have to come into compliance with the tree ordinance, and there is a landscaping requirement in the tree ordinance, but as far as stormwater retention, any area that they increase, any impervious area that they increase, they'll have to account for that in their stormwater management.
So are y'all amenable to putting 2 parking spots in that back area to get you to 7 parking spots?
That would be what we would want to do. Is that your question? I'm sorry.
Yeah, the variance we have before us, or one of the variances we have requested is to go from 7 required down to 5.
Correct.
But you're on board with having 7 spots.
Yes, yes. I did both just to cover all bases instead of having to file another variance and wait.
Is your
So I-
concern that if your stormwater retention plan affected or impacted your ability to use that back area to put 2 more spots? Is that what you're thinking? That if that didn't allow that, then you'd be stuck with 5, and so you're asking for the variance just in case you can't put 2 back there?
Correct, correct. So if we couldn't put 2, then my next step would be to try to reduce it to 5.
But you do realize it has to be asphalt, concrete, you can't keep it in gravel.
Correct.
Okay.
Yes, sir.
Have you taken steps to look into that, or any plans or anything for putting 2 spaces out there?
Yes, that's what in our original plans that we had drawn up, we had plenty of room for 5 spaces, actually.
Okay.
In the back.
In
So
the
a
back.
total of 10.
At one point, they showed a total of 10.
Correct.
Okay.
Just the main thing is the bottom front, being able to back out. And like I said, in the report, you look down Linden and it's everywhere. The code was really written for a more commercial area, and this used to be a residential area that transitioned over the years. So it definitely, it's not a cookie cutter commercial lot.
Yeah, so that all makes sense, assuming that gets approved and he's amenable to adding 2 spaces in the back of the building.
Then it's gonna affect pulling out of those spaces at the back of the building also, onto a street or an alley.
Okay. Is that what variance A is asking here?
Variance A is, yes, no.
No,
variance
that's
A is
7
a
to
reduction.
5.
It's, B is to allow, spaces to be directly accessible.
does that cover Linden and the alley?
Yes.
Mhm.
Okay.
In which, if y'all, I don't know if y'all seen that alley in the back, it's pretty narrow and there's no traffic or any cars that I think I've ever seen drive down it. So it wouldn't be a huge risk for people pulling out onto a busy street.
Okay.
Yeah, but you do have that alley to the immediate north that you border that, depending on the way you arrange your parking spaces, they could pull out into that alley. I agree that the other one to the west is very narrow, but the one that borders your property on the northern side could possibly accommodate a car backing out. Could.
And when you say north side facing the building, it would be to the right there?
Yes. So, you know, however you end up configuring these parking spaces, you can go north or west
Perfect.
from the back.
So if we deny A and approve B, is your plan to just resubmit a site plan that shows 7 parks, 2 being off the back of the property?
Correct.
Which then it would fall in
Yeah.
compliance with everything?
Yeah, kind of thinking like from a cart and horse standpoint, the questions, basically the way it's on the 5, at least the 5 requirements being presented is, we'd like to be able to do it in case we have a hardship, as opposed to, we need to do it because we have hardship, if that makes sense. He said ideally he would put 7 there, and ideally he would put 7 there. I think we'd all agree on that, but.
I would think you would want more parking for your tenants.
Yes, because if you didn't and we got it to reduce it to 5, you just have people end up pulling back there on natural ground anyways and parking, like everybody in that surrounding area. Kind of
Okay,
doing.
I'm good.
So knowing that we're all, including the applicant, all on board with 7 parking spaces, do we want to consider B, or do you want to resubmit with 7 parking spaces and?
You mean A? You mean
Yeah,
A?
yeah,
A is a
A.
reduction from 7 to 5. That,
So I think voting on B and getting that approved to be able to pull in and back out, then when we resubmit, then it would, our plan, then it would, I guess, be approved if that's the process.
because you now have a variance. Yeah, I mean, that makes
That's
Makes
why I
the most sense to
suggested
me.
that you
Split them.
split them.
That's right.
Yeah.
Put on them separately, yeah.
okay.
All right, do you want to split the votes when we get there?
Yes, and I don't know if y'all could vote on B first, then we could end it there.
Yeah,
So
yeah.
do we want to vote on A, or do you want us to set A aside and not consider A?
If
you want
B
to-
is disapproved, then vote on A, I guess is what I'm saying. If y'all deny B, then I guess vote on A. That makes sense.
So you want both A and B to go forward?
So
Oh,
we can just pull,
let's-
if, I think y'all are in agreement, we can just pull A.
Yeah,
Just
Let-
vote on
if you-
B.
let's just
if
make a
you
motion on
want to
B, and
withdraw
then-
Yes.
The variance
Yeah.
request.
All right, I make a motion,
Yes,
Yeah,
Okay.
no, yeah,
perfect.
All right, so you're withdrawing
A,
A.
yes, ma'am.
A, okay.
Which is 7 spaces
To
to 5.
5.
You want to
Yes.
set
Vice withdrawing that.
He's withdrawing that request.
Okay, right.
with the understanding that if B is approved, you will have 7 parking spaces at that property.
Correct.
Mhm.
All right.
I move we vote on case number SV 22-03-03 with regard to
Second.
Mr. Parker, who made the
I second.
Second,
Yes.
right.
If you
Okay.
call the roll, please.
Wait a second. Okay, all right. Mr. Wortley,
Yes.
Mr. Alsabrook,
Yes.
Mr. Perkel,
Yes.
Mr. Gear,
Yes.
and Mr. Roberts.
Yes, your case passes 5-0.
Thank you, guys. Sorry for the confusion. Appreciate
No,
it, guys.
sorry.
Well done. Great with all that.
Okay, our next case is AP 22-03-04. It's an appeal of a decision of the Department of Engineering and Zoning relating to 310 Poinciana Drive. The applicant is Yaroslav Klimchak, we believe represented by counsel. Okay, if you come forward, I think, just for the benefit, we don't have many appeals like this, and so procedurally, I think it makes sense for at least us to understand kind of where we are right now. And I'll at least give you my understanding based on the record I've reviewed, and I'm sure the city will want to correct some of my misstatements. But my understanding is that this case was submitted to the city as a request for a 10-foot left side setback to allow for an existing patio to be covered on the left side of the property at 310 Poinciana Drive, and that setback variance would allow a roof line basically to go all the way up to the property line at 312 Poinciana Drive. My understanding is that the city, in receiving this, noted that under the existing ordinance, the city zoning ordinance, that because lots at 310 and 312 have common ownership, and that because they both independently would not comply or not conform with the zoning requirements in terms of the size and dimensions, et cetera, that they are therefore under Article 3, Section G, considered a zoning lot. And that same section says a zoning lot, that no building can be done or permits issued for building on such a lot unless there is a resurvey of the lot into one lot that is conforming. And that because there is an avenue or a way for the applicant to accomplish what they're trying to accomplish, a route to relief, I guess, is another way of saying it, there's nothing for the BZA to consider. And again, because the ordinance is clear that no permits can be issued for zoning lots without there being this resurvey, that the city's position is this issue is taken out of our hands. And I'm sure I've misstated that to a certain degree, but is that okay? And so we understand you're here today, and if you could just state your name, please. If you didn't already, I'm sorry. If you did already, I'm sorry, but.
Bert Boykin,
Okay.
along with Jesse Evans, my law partner. I'm here on behalf of the applicant. I believe you framed procedurally where we are correctly. We obviously disagree with staff's interpretation of the zoning ordinance and how it applies to this lot. But really what's before the board tonight is, as you stated, an appeal. And in December, we filed this application, and then in January, we received an email from staff stating the interpretation that you just recited, and that we could not have a hearing on our application. And the basis of our appeal is the Alabama Code 115280 in Section A, Article 4 of the zoning ordinance provides our right to appeal a decision of an administrative officer. So that's what we're doing tonight. And the planning staff does not have the legal authority to look at an application, interpret it, and apply the zoning ordinance. That is this board's duty under Alabama law. And only the board within the city can do that. The staff is not granted quasi-judicial authority such as this board is. So when a property owner submits a variance application, it has to be set for hearing so long as the, filing fees paid and there's enough there in the application to move forward, which I believe that's not the issue here. It's just they interpreted the ordinance and said, you guys aren't entitled to a variance. But we believe, and I believe Alabama law clearly supports our right to have that application at a subsequent hearing set where we can go through this variance with the board. So that's really the question tonight, whether we're entitled to a hearing, because staff sent the email saying you're not going to get it. We followed up and said, all right, are we having our appeal set for hearing on the 3rd? That's what was confirmed. So I think that's the way it's been noticed, the way publication has gone. So we're asking the board to reverse staff's decision and set this at a subsequent hearing.
Okay, so we're on the same page. Well, let me back up. Did you have anything else before I open
No,
up the public?
I'm ready to
Okay.
address any questions.
Okay, this is a public hearing, though.
Okay.
Before we ask any questions, if any member of the public wants to speak to this case, this is your time to come forward. Okay. And seeing no one, we will close the public portion. Mr. Boykin, if you could answer any questions that the board has.
Absolutely.
And I'll start just by making sure we're on the same page in terms of what's being asked. The appeal tonight is simply seeking a vote from us as to whether or not we have the right to, at a subsequent date, consider the variance at issue.
Correct.
And I have the zoning ordinance in front of me in the code section that discusses the Board of Adjustment and its rights, abilities, specific enumerated powers, et cetera. What specifically are you citing as your support for the premise that the city or the Department of Zoning and Engineering, and I don't know if I'm even giving the right department name there, but that the city has the right to, or doesn't have the right to tell an applicant that your case is not, does not merit a BZA review?
Well, the BZA is unique in that, I think as I stated earlier, it's allowed to make quasi-judicial decisions, use discretion when looking at variance applications. Staff is not provided that authority through Alabama law. The legislature has enacted a specific statute that allows this board to consider variance applications. Staff cannot interpret the ordinance under Alabama law. There's just no support for it.
What is that statute?
115280.
80?
Yes, sir.
And that's a pretty long statute, with several subparts. Is there a specific part? Are you talking about the powers provision?
Correct.
So that would be subsection D. It says the Board of Adjustment shall have the following powers: to hear and decide appeals where it is alleged that there is an error in any order, requirement, decision, or determination made by an administrative official in the enforcement of this article or of any ordinance adopted pursuant thereto. Is that part of what you're
And
citing?
then 2, to hear and decide special exceptions to the terms of the ordinance upon which such board is required to pass under such ordinance. And then to authorize upon appeal specific cases, such variance from the terms of the ordinance as will not be contrary to the public interest, as it goes on. So those are the 3 powers granted to this board. Staff does not have those 3 powers. So when an application is submitted, staff can certainly have their opinion of it and make that known to the board, but the board has to make the ultimate decision about an interpretation and whether a variance is due to be granted.
Under that code section, what are you alleging is the error in their decision?
The error is that they simply cannot push away a variance application. This ordinance gives the board the power to grant or deny variance applications. There's nothing in here nor anywhere in Alabama law that says planning staff or any other part of the city of Homewood or any other municipality can make a determination that a property owner is not entitled to a variance.
But specifically, 115280 sub D1 says that the Board of Adjustment shall have the following powers to hear, decide appeals where it is alleged there is an error in the order requiring decision. What part of the staff's determination do you contend is an error? Is the subject property contiguous?
It is. But the error is that they didn't allow us to have a hearing on the application. They cannot deny it. That's this board's duty to review applications. So D1 is the power to hear an appeal, such as what I'm bringing to you right now. D3 is the power to review, grant, or deny variances. And I'm saying that's a specific power granted to this board that's not given to anyone else within the city of Homewood or any other municipality. So staff simply does not have the legislative empowerment to look at an application and say they're not entitled to this variance. So we're bringing the appeal under D1, but ultimately D3 is what this board uses to review variance applications.
Refer to the minutes of the July 10th, 2014 meeting. And there was a hearing on this.
July 2014?
July 2014, when there was discussion that before a building permit could be purchased for a zoning lot, that it had to be resurveyed and done.
Yeah, I know I've reviewed that. I know, is it when Ms. McGrath, yeah, on page 7 of those minutes, Ms. McGrath stated the new owner could and would need to, if they were going to build a house, they would need to go through the process of having the entire property replatted.
But again, I don't think that prohibits or has any bearing on what I'm asking the board to do tonight.
So you're saying, what the city's position is that their argument as to why we shouldn't approve it, if it got to us, your position is it should have at least got to us.
Correct. We're entitled to a hearing in the future where we can go through that issue and any others that the board might have. But we were told that, staff made the determination you're not going to get an opportunity to present your case. So we're asking for the opportunity to present our case.
Okay. In the city's, I understand the city's explanation for why this has to be replatted before anything can be done, any permits can be pulled. What is the city's position with respect to, from a statutory perspective, the other piece, which is that the city has the right to prevent that from coming before us, if that makes sense?
If something is prohibited, you cannot grant a
I guess my question is then, you know, you're prohibited from building a accessory structure that's 25 feet tall within 5 feet of property line under the
But
ordinance.
the use itself is a permitted use.
Okay.
So what you're doing is just varying where it is placed on the lot. If, you know, trying to think of another example of what, something that was not permitted, a use that is not permitted on a residential lot, we do not allow it.
We couldn't, if someone came in here and said, I'm in an NPD zone, a residential place, I would like to run a laundromat,
Correct.
that's not a permitted use. And I get that, and the NPD, the code itself is very clear. So the distinction is that, I guess I'm still trying to grasp that. So,
I mean, it sounds like it's a filtering question. Does staff have the right to filter out cases or not?
yeah, Mr. Boykin,
Is that-
if your client was coming in here and asking you to build a nuclear reactor at the same location, just for sake of being ridiculous, and you went to the city and the city said, no, the guidelines do not allow for, specifically exclude or preclude nuclear reactors, is your position that you would have an automatic right to appeal to us to make your case as to why a nuclear reactor would be appropriate?
In that extreme example, I think so, and we have a right to have an application considered by the board that has the power to consider it. This is as was stated, a filter prohibiting a citizen from making their case to the board. Now, you know, at the end of the day, that's really all that is before the board tonight is, are they able to stop us from having our hearing?
And again, I'm reading D1 and 3. D1 is why you're here tonight.
Correct.
It permits you to appeal a decision by a state or a city administrative official, which is what we're talking about. And that's why we're here tonight. Number 3 grants the Board of Adjustment the power to authorize variances to the ordinance based on a showing of a hardship.
Correct.
Is there anything in there that, as opposed to explaining the powers of what we can do, says what we must do in terms of taking on cases? Or is there anything in this statute that says a citizen who disagrees and believes that he or she has the right to a hearing is automatically entitled to a hearing on the underlying issue, not just the appeal, but on the underlying issue itself?
Well, the D3 doesn't go on as you stated, but I think what we're looking at here is a specific grant of power. And that does not go beyond the BZA. If that were the case, then municipalities or counties or whomever could just, allow staff or other parts of the city to make decisions that are not authorized under law. So this board is started and granted power through this statute, and that cannot be transferred.
Again, the statute gives this board the power to hear the case and make decisions and make variances, allow variances based on circumstances and the showing of an undue hardship. But there are certainly circumstances where an application doesn't come in time, or the application fee isn't paid, or there are other, I can think of many other reasons. They didn't use the right form, they didn't sign it, they didn't give an address, where the city would say, no, you haven't done what you need to do. And in those cases, are you saying that the applicant, despite not complying with the technical requirements of the application process, would automatically be entitled to a decision on the merits of their case?
No, sir, I'm not saying that. We paid our filing fee. We provided an adequate application. Those would not be justifications, nor was it the justification given for the denial of our opportunity to present this case. So no, I'm not representing to you that I can file the phone book up there and then get my hearing. It has to comply and put the board on notice and provide enough information to publish, money for, you know, all the publication required. So yeah, those have to be met, but at the end of the day, that's not what we're dealing with here.
Okay, but you would agree with it in the circumstance where someone doesn't pay a filing fee, that an employee of the city who's not a member of this board, an employee of the city could prevent that case from going forward to us?
I agree. If the city never collects a filing fee, then they can hold that application. Upon the filing fee being paid, that prohibition's gone. You know, basically, the staff made a decision on the merits of our application. And that's what we have appealed.
No, the staff didn't make a decision on the merits of the application. The application is seeking a determination that a hardship exists that allows a non-conforming structure, otherwise non-conforming structure, to be built. That would be a decision on the merits of the issue. The city's position appears to be the BZA can't fix what impediment's already there. We can't give a variance where the ordinance says you gotta replat these lots into one lot that complies. Anyway, that's.
I mean, the email, which is attached as an exhibit to our appeal, says a variance is not appropriate since ownership of the adjacent lot provides a route to the relief sought. That's a decision on the merits of the application. And there's a distinction that we will be prepared to make to you about the ordinance and the way it reads and how it says the zoning lots have to be combined into one lot when they have common ownership. And there is not common ownership between these two lots. But again, that is getting beyond what we're talking about tonight. And staff simply cannot sit there, look at an application, interpret the ordinance and say this does not, number one, deserve a hearing, and number two, it's not a variance that can be granted. That's solely with.
With regard to the board's determination, the staff's determination, the city determined that the subject property is contiguous and is under common ownership. It's your position that it is not under common ownership, and that is an error by staff.
That is an error. That's an underlying error that comes below the fact that staff even made that determination at all. Now, staff can have an opinion, as I stated earlier, and they can let you know what they think, but ultimately, the board has to interpret the ordinance and apply it to the application.
Yeah. My position is that D1 says we can hear and decide appeals where it's alleged there is an error. If you are saying that they're finding that this parcel, these two parcels are not under common ownership, then that would be error. And I think that under D1 then opens it up for us to hear an appeal. But is what you're saying that staff was incorrect and these parcels are not under common ownership?
Yes, I think that is an error, but, I mean, I know I've said it, but their decision to not allow us to bring that to you is the ultimate error that's being appealed.
Yeah, I disagree with that. I think that what the code says is they can make determinations, and if you're appealing an error they made in that determination, then we can hear an appeal.
Okay.
So, you know, we have different interpretations, but if under my interpretation you are saying that the city made an error in saying that these parcels are under common ownership, I think that opens the door for us hearing an appeal.
Fair enough.
If what you are saying
That is what I'm
to the
saying.
board tonight
Yes.
is that these parcels are not under common ownership.
Correct.
Okay. My feeling is the code says frankly, that the city can make those determinations. Here's what the ordinance says, these are the things, they made the determination based on the code section and the zoning ordinance, that because the subject property is contiguous, is under common ownership, does not individually meet the area and width requirements for the NPD, must be combined to form one lot before the issuance of a building permit, and shall not be used in a way that conflicts with the zoning ordinance. That's what the city found. And that's a determination they can make under the zoning ordinance. If, however, the allegation is that one of those 5 determinations was in error, then I think Alabama Code Section 115280 D1 allows us to hear and decide an appeal, where in this case it's alleged there's an error in any order, requirement, decision, or determination made by an administrative official. That doesn't mean we have to prove it. I think it simply means that we have to say, yes, we can hear your arguments at a time in the future.
I think in terms of clarification, it may be an interpretation in terms of the ownership issue that Councilor Wright. It was my understanding, is it not, that one of the properties is under the name of the owner and the other's under the name of his wife? Is that the distinction you're making, that they're not under common ownership, even though the husband and wife both own the lots separately?
That's correct. One, Mr. Klimkak owns the lot that is the subject of this appeal and variance, and then Ms. Klimkak owns the adjacent lot.
So again, that's an interpretation as to, is that common ownership, or is that a distinction, subtle distinction?
About that, has that changed since December?
Not to my, no, it has not changed since December.
Because on December 22nd, there was a quitclaim deed filed, as well as a mortgage, and for both of these parcels, or both of these lots, and in, both names.
You mind if I see what you're talking about?
Just a reminder, everybody, if you could turn on your microphones when you're talking.
Ms. Williams, what is the city's position on whether or not city staff has authority to turn away applications for board hearing? I don't see that in the write-up. That seems to be the root question.
In this particular case, the 2 lots meet all of the requirements for zoning lots. And they would need to resurvey those 2 lots into one lot in order to get a building permit. If they were in separate ownership, I would have to advise, okay, yes, you could ask for this variance to reduce your side setback from 10 feet to 0, which is what the request was going to be. But the fire chief and the building code are not going to allow it to happen. So you can still ask the board, but the board can't grant, you know, a variance to the building code or to the fire safety code.
So is it?
And in 14, again, during a hearing on this matter, you know, it was stated that they would have to resurvey.
I just meant as a philosophical question. Is it, because it seems like he's zooming out to ask a bigger question and challenging.
Can I jump in?
Yeah.
So I think back to the nuclear reactor, if it's not permitted, then we don't bring it here.
Okay.
So my understanding, the staff goes through checks and balances. And if it doesn't meet a certain criteria, which you went through your checks and balances, and it did not deserve the opportunity to go to the BZA because it did not meet the criteria, is that what we're saying here?
It just wasn't allowed per the zoning ordinance.
Correct.
It wasn't
Right.
permitted.
So if it's not allowed, so there's not a reason to move forward with the BZA.
Correct.
And if I could, just state one more time. Well, first of all, I haven't seen these deeds. I'll speak with my clients about it, but again, that's not what's at the heart of the issue tonight. The code section, we've looked at it and gone over, is for the Board of Zoning and Adjustment. It is not for the City of Homewood. It does not grant the City of Homewood the ability to review, approve, and deny variance. It grants this board that opportunity, or it has the exclusive power. So that's the heart, and really all that we're bringing to the board tonight is that we deserve the opportunity to present this case at a future date, and that staff does not have the ability to turn something away unless, you know, a filing fee hasn't been paid, or obviously the application's deficient, which is not the case here. They just interpreted the ordinance, which they don't have the power to do.
Yeah, that's kind of what I was trying to get to. I'm not a lawyer, so it would be, I don't know, helpful to have somebody from legal weigh in on that.
Well, Mr. Wood, your position is that we're only here to decide if we can hear this at some later date.
Essentially, yes, sir.
And your position is that, for whatever reason, your position is that the city made an error in their determination that it could not come before us.
Exactly.
And my feeling is, under the code, we are simply deciding tonight if there is an error, and there is error alleged here. We'll get the documentation for the quitclaim deeds, presumably, and entertain argument down the road about whether or not they do meet these criteria. But if the suggestion, well, Mr. Boykin on behalf of his client says that there is some error, I think the code allows for us to vote on whether or not they should be allowed to bring evidence of that error before us. We're simply deciding, do we want to hear from them? Can they say, we get to hear from them next month or Monday?
Yeah, understood.
Yeah, if this had been pitched to us as the city erred in determining that these two lots had common ownership, we had evidence in front of us to consider on that, we might be ahead of where we are right now. The way the case was stated is that the city planner's office has no authority to prevent cases from coming in front of us. I think the sense is, at least from what I've heard so far, is that there are circumstances in which the city planner's office can prevent applicants from having cases heard in front of us. So I think that's where we are. I think we probably ought, But procedurally, we vote on whether or not that it's whether we have the ability to hear the appeal based on an error on property ownership?
I think so.
I have a question. In order to do that, I'm just trying to be thorough here, my understanding, would the applicant would have to be able to provide us information that there is error?
Well, I think that, yeah, at the later hearing, I mean, they have to make their case. Yeah, I think tonight is simply a good faith assertion by Mr. Boykin that there was error. And he's specified where he believes there is, or at least one area where there is in the city's determination. And then at the next hearing, it would be, here's where the error was, here's the evidence showing that it was error. Now, setting all that aside, here's why we believe we want the why we believe we deserve the variance. Now vote on the variance.
Understood.
Anything else?
I guess, my question would be, does the board hear everything even when they can't approve it?
I think, and I think one of the threshold issues is that a determination as to the ownership and the common ownership of the property itself is a threshold issue before we can even get to the issue of whether or not we can entertain it, if that makes sense.
It's a decision on the merits of the application.
It's the decision on the merits of the application. It's not the case that's in front of us today.
Right.
I think the question is today is, I mean, the way the case was pitched is it would be a vote on whether or not the city planner has the ability to be a gatekeeper for what cases come in front of us.
And that's my question. Can planning and zoning and engineering staff, do we just stamp everything in and bring it to you, even in a case where you cannot approve it?
Even if it's not permitted.
Right. If it's not something you can allow, something you cannot grant a variance to.
So, again, going back to just this core issue, which is, if the city's basis for saying that this cannot be anything we can't approve is that this property, these two pieces, these two lots, these contiguous lots, non-conforming, pre-existing, non-conforming, contiguous lots, have common ownership, which is a factual determination. And it might be an easy one, it might be a hard one, we don't know. But I think you have to address that threshold issue before you can decide the second issue, which is whether or not we have the ability to approve something, I think. If the evidence was 312 Poinciana was owned by a stranger, at arm's length,
Right.
stranger, and they wanted to put a roof over this. Okay, well, let me back up just on that same hypothetical. If they came to you and Mr. Gear owned 312, and they wanted to put a roof over this patio, and you know from the fire code and from, from the city ordinance, and you know all this better than I do, but that can't happen. What happens in that case? Do you tell the applicant you can't go forward with this?
If I had the documentation like we do, where the fire chief had said at the previous hearing, that area has to remain open, that 10 feet to the property line must remain open, then you cannot grant a variance to the fire code or the life safety code. You can't, that's not within your power. The fire chief has said no. So even if you were to say, well, yeah, you can, you know, yeah, we'll grant this variance. They can't do it. It's already been stated in a meeting before the board that they must keep that open.
Okay. And I think if the city's stated position for denying the opportunity for the appellant in this case to come before us seeking a variance was the fact that the fire code prevented this variance from being issued, that I think we're looking at a completely different analysis than we are now. But that's, I didn't understand that to be the city's grounds. But I understood the city's grounds to be the
Yeah,
zoning.
we sent all of the information to them over the last couple of years while these conversations have been going.
Mhm.
We've sent the minutes, we've explained, you know, here are the minutes from the previous meetings, which included the letter, the 2014 letter from the fire marshal at the time, now Chief Hill. So all of that information was given to them as our reason why, you know, in the statement that was made in the hearing before this board, that the lots must be resurveyed and combined before a building permit could be issued. So a hearing was, they did have a hearing on this matter. There were determinations made. Staff is just enforcing the determinations that were previously made.
So just a real quick question. Mr. Klimkat is the owner of 310 or 312? 310. Okay. And
Actually,
Ms.
both of them.
Yeah, but he maintains that there's separate ownership, so, but 310, okay.
Mr. Chairman, might I speak for a moment?
And if you'd state your name for the record, tell us
Yes,
your.
sir. My name is Jesse Evans. I'm the other lawyer for the Klimplex who is here tonight. Bert and I both represent them. You know, we're not here on a very sophisticated question. Our question really is this: can we possibly prove that there was an error? Not whether you decide that error tonight, but the question is whether or not we are entitled to, at least once we've filed a proper application, once we've paid the filing fee and done everything else that we should do, are we entitled to a hearing before you? Or can the administrative staff come in and say, well, we don't think you're entitled to this variance? Or, now, if we hadn't paid the filing fee, okay, I'll give that to you. If we hadn't filed a proper application, I'll give that to you. There's no question about it. If we've not procedurally required or met all the requirements of your ordinance, we're not entitled to be heard. But we have met everything procedurally. And I think 1152 is 80 or 81, the statute that we were talking about. That statute says that that's part of your jurisdiction. It's kind of like going to court. If you file a lawsuit, a court's got jurisdiction. And they've got that jurisdiction. The clerk can't say, no, we're not going to take that lawsuit. Now, they can if I don't pay the filing fee. They can if for some reason I hadn't procedurally complied with something. But in this case, we have complied with everything. And I think that statute imposes a duty to at least give us a hearing. That's all we're asking for is a hearing.
Mr. Roberts, would it not be then up to staff to enforce whatever decision then that you were to make here tonight? You know, if somebody comes in for, regarding the variances that you've previously approved tonight, Twin, for instance, comes Twin comes in to get their permit, and they are showing us something completely different than what you have approved. Is it not up to us to enforce what, and to make sure that the people follow the rulings that you have made? Is that right? Staff is supposed to ensure that variances are
Well, staff cannot grant variances.
correct, but it's up to us to make sure that the applicant meets any requirements that you have put on them, or that the variance, that when they do build something, that it meets the terms of the variance, correct?
Yeah, if what they're presenting to you for a permit is different than what's been approved by this board, then you would have to be the gatekeeper of that, no
Right.
question about that.
Mr. Armstead, let
And,
me.
so I believe that in this case, that is what's happening.
Well,
You made a statement that was quite profound, that is, or she did.
I've never been accused of that.
That the staff cannot grant a variance, and I agree with that fully. Staff does not have the authority or the jurisdiction to grant a variance. But by the same token, if you turn that leaf over, staff didn't have the jurisdiction to deny a variance either. And it's rare that I get into a situation, I don't recall having been in a situation where the staff was actually taking a position different than an applicant before the board. We're not here to talk about merits. We're here simply to say, listen to our merits when it comes down the road, when we come back to you. You may tell us that you're not entitled to a variance, and we're not gonna give you one. And if you do, that is a decision the Board of Zoning Adjustment has jurisdiction to make. But the question about staff being able to tell us, we can't even come to you, is totally different. You know, of course, it'd take an hour for me to try to explain this, and I'm not really, hadn't studied up on it, but, you know, the Second Amendment of the United States Constitution says that a person's got a right to petition their government for the redress of grievances. That is the reason that the variance is allowed for in zoning ordinances. That's why in 1926, when the Department of Commerce wrote the Standard State Zoning Enabling Act and gave those powers to a BZA, that's exactly why it was in there. was
And
because of
that's
that Second
exactly
Amendment.
what they did in 14.
Don't argue.
I know.
Mr.
It's
Evans,
just-
is it your position that
They've done it.
setting aside there was an error in determination by the city, that this request still violates the fire code for the city, that there is no reason to
Well-
have a hearing?
No, that's not not my position at all, that there's no reason to have a hearing.
Would it be elementary at the hearing for us to simply say, to meet the fire code, sorry?
Well, you know, if we couldn't meet the fire code, yes. But what our plans may be at this point is, may be a totally different thing than what was heard before. You know, there is nothing in the zoning ordinance that prohibits, making another zoning another BZA application, another variance application. There's nothing there. And some time ago, one was made and it was denied. We
Well,
weren't,
I think we're in a different situation here where you are appealing for us to hear this specific application.
we are.
If you're saying we're withdrawing it and gonna start all over, that we don't need to vote on it.
We're not. What we're saying is this. We're saying that we came to you and we filed a proper application. There's no defect in our application. If there is, somebody please tell me. 2, we paid the filing fee. If we didn't pay it, I think we did. Please let me know. Is there anything else that if I want to get a variance from you that I need to do other than file a proper application, or at least if I want to be heard on a variance, is there anything else that I need to do other than file a proper application and pay the filing fee?
If the application is facially violative of the city ordinances?
But this one is not.
No.
Oh, I mean, yeah, if I said I wanted to put a nuclear reactor in a residential area, I think that, you know, probably, but, you know, no one would do something like that. No one would come to you and want to put a nuclear reactor in a residential area.
My understanding tonight is that this application is facially violative of the fire code for the city of Homewood, setting aside whether the city made an error.
Our application doesn't go there. Our application says to hear our variance and the reasons why. We're not even into the reasons. We've not articulated those reasons at this point. And the reason for it is because our application has been rejected, just our application. All we're saying is accept our application, reverse the decision of the administrative officer, accept our application, let us file the application, let us pay that filing fee, and let us bring that to you at that point at a subsequent time. That's all we're asking for. We're simply asking for a hearing, really. That's it. Now, I don't know of anything in the zoning ordinance anywhere that says that someone other than the Board of Zoning Adjustment can make a determination as to whether somebody is entitled to a variance or not. I don't know where it is, if it's in there, either in your ordinance or in state law. And I believe, I've never seen a situation where a person who filed a proper application, paid the fees, and nobody can point to a procedural defect in what we've asked for. I've never seen a situation where a Board of Zoning Adjustment wouldn't hear us.
No,
And that's
it's
why
not-
we
not a
appealed it.
procedural defect, but a facial defect, I mean, something on the face of the application.
Well, such as.
The application is in violation of the fire code for the city of Homewood.
But that's not the application. This application is, we'd like to have a hearing. That's another application. That's a different application. Our application now is, we believe the decision of the administrative official was wrong, and we'd like to, we ask you to let us have a hearing. The question of whether or not there's a facial defect, that goes to the merits, and that's a different application. That's not this application. Our application here is, will you give us a hearing?
May I speak? Just kind of about to what you're saying here. So the previous application was submitted in December 21, and that was requesting a variance.
Okay.
Okay, so that's what I have here as an Exhibit B for my records. But you're currently appealing that.
Now, we're appealing the refusal to accept that application. You've never heard that application. That application was essentially de facto denied by the administrative staff. It's that application we want to bring to you and present to you for a variance, with the possibility of a variance.
So if we vote to grant you a hearing, it will be on that application.
That is correct.
And if that application is facially violative of the city ordinance, why should we hear it?
Then, because we're entitled to a hearing under state law and under your ordinance. Now, if it's facially violative of some ordinance or the like, then possibly that's a ground for denial. That becomes a matter of discretion for the board,
Not under D1.
which says, because I'm not,
We have the ability to, we have the following powers: to hear and decide appeals where it is alleged there is error in any order, requirement, decision, or determination made by an administrative official.
All right.
So it's your assertion that the facial violation found by the city of the fire ordinance is an error.
no, we're not saying that. One thing that that Mr. Barkin mentioned is the question about the separate ownership. The husband and wife owning one lot and the husband owning the other.
Right, setting aside separate ownership.
Well, but that's an error to make that decision.
But if there are more than one problem with the application,
That-
one
that-
of which is that it's facially violative of the ordinance.
Well, but here's the thing, though, that is an area variance. That's a permit matter, that if we came to get a building permit from the city, okay, we can't get a building permit because of the setback violation. What do we have to do? We gotta come and ask for a zoning variance, if that can be done. If it can't be done, it can't be done at that point. But that's way on down the road. All we're asking for now is just, hear our December application. That's all we're asking for.
I'll move we vote on AP 22-03-04.
Second.
And just,
A second.
and just to be clear, what we're voting on is whether or not to authorize a hearing on the underlying variance application from December.
Correct.
Okay.
Okay. All right, Mr. Hortley,
Yes.
Mr. Alsabrook,
Yes.
Mr. Perkel,
No.
Mr. Gear,
Yes.
Mr. Roberts.
Yes. Okay. So your case, or your appeal has been passed by a 4-1 vote.
Thank you,
Means you'll
gentlemen.
be placed on, I assume, on an agenda coming up for consideration of the actual underlying request.
Thank you very much.
I'm sorry. Next case for tonight is, because we're skipping, the fifth case is 306 La Playa Place, SV 22-03-06. The applicant is Paul Bates. Whoever's presenting on this case could please come forward. And thank you for your patience.
I'm Paul Bates and Mims Cooper.
I am Mims Cooper. I'm the homeowner filing for a variance for property at 306 La Playa Place, Homewood, Alabama. My address is 308 La Playa Place, Homewood, Alabama. And Paul is my architect. And Mr. Goodwin is handing out paperwork.
Thank you.
I got On page one, this is a photograph of my house. I live in the White House, 308 La Playa Place, and I bought this property in 2012. The house to the right is 306 La Playa Place, and I bought that property in 2019. And my plan is to tear down the house at 306 La Playa Place and build a 2-bedroom, 1-bath home on that property, a 1-story structure with all of the parking in the back of the house. There will be no parking in the front of the house. There will be no parking pad in the front. On page 2, this is a photograph taken from the front yard showing the two houses. This is page 2. On page 2, this is taken from the front. The White House on the left is the home that I live in at 308, and the house that will be torn down is the property on the right, which is 306. And the variance that we're going to be asking for is in this corner, this left-hand corner of the house on 306, which is the yellow house. Slide number 3 would be this slide, and this is explaining the variance that I'm requesting. The blue line in the middle on page 3 the blue line is the existing wall for 306 LaPlaya Place. That is existing wall as it stands today. The red line to the right is the 10-foot setback. So the existing home is 1 foot 10 inches over the setback. And the kitchen that we want to build will be to the left, which will extend 1 foot 2 inches past the existing wall structure as it stands today. And this is where we're coming up with the 3-foot variance. The setback in this part of the house will be a 7-foot setback versus a 10-foot setback.
Thank you.
On page 4, this gives us a layout of the property on page 4. On the left-hand side, in the green box, that is the White House that I currently live in. And in going up the page there, that green box at the top is the existing garage on my property. It's a detached garage. Moving over, the red line in the middle is the setback, the 10-foot setback. And down in the lower left-hand corner is the kitchen area, which is that small little orange box. So the orange box is 3 foot over the setback, but again, that little orange box is only 14 inches past the existing wall as it stands today. And in this area, the setback would be 7 feet versus 10 feet in this small area. Moving up to the top, the orange box at the top of this page is the garage. And it would also be 3 feet over the setback. And so between the property line and the garage would be a 7-foot setback versus a 10-foot setback. The existing garage in the green has no windows facing, going to the right. And the garage that I plan to build will have no windows on that side either. The yellow section in the middle, which is the majority of the house, the yellow section, it sits 3 feet behind the setback. So in that part of the house, rather than being a 10-foot setback, that yellow section will be a 13-foot setback. Turning the page to page 5. The yellow box in the middle is the property that we're talking about. That's 306 LaPlaya Place. And I went around to all my neighbors and told them that I was building this house, which they all knew that I was building the house because I bought the property in 2019. And told them showed them all the plans, answered all the questions, told them I had a variance for 3 feet. Showed them all the same slides that we're talking about today. And asked them if they would support the variance, and they said that they would support the variance and felt good about it. The thing that my neighbors were most excited about, me building this property, was three things. One, that we will tear down this house that cannot be renovated. It's completely beyond renovation, so we'll tear down this house. The second thing that my neighbors like is it's gonna be a one-story structure versus a two-story structure. And the third thing that folks like is that all the parking will be in the rear of the house, and we won't have a large parking pad in the front. All the parking will be in the rear of the property. And on the last page, page 6, after I went through this with them, I made them sign off that they had looked at the plans and answered all the questions. And these are all the neighbors that are in this red box here, with all the adjacent neighbors that I had talked to them about the property and told them what my plans were and what we had planned to do.
Okay, this is a public hearing. If anyone here present wants to speak to this case, this would be the time to come forward. Seeing no one, we will close the public portion of the case and open up for questions from the board.
Mr. Cooper, I appreciate your diligence in surveying all the neighbors. This is a complete tear down of 306?
Yeah.
Given that you are limited only by your imagination for a conforming plan for the new house, why the need to build a house from the ground up that requires variances?
Right. I bought the White House in 2012, and the renovation budget on that, quite honestly, was about $300,000. And when it was all said and done, it ended up being almost $800,000. We got to the end of the project, and I asked my builder, I said, no harm. Should I have torn this house down? He said, you probably could have torn it down and built the same size house for less money than we've put in this renovation. I like renovating houses. This is the 4th house that I've renovated. Done a couple of them in Forest Park and Altamont and Redmont. And I bought the White House because I like those Spanish houses and want to renovate it. This house here is completely beyond renovation. A large tree fell on it in 2018. The back of the house is completely gone. The ceilings are falling in. If it can't be renovated. I keep the grass cut, keep the bushes trimmed, but the house is in horrible shape. You go in the back, and rooms are literally falling in because it's just been in such disrepair for all these years. The roof leaks like a sieve, and so it cannot be repaired. It's has those clay blocks in the walls, and it can't be done. It just can't be done.
But after tearing it down.
Right.
We agreed.
Yeah.
Can't you get plans for a home to be built that doesn't require a variance?
If I could just.
Yeah, go ahead.
Yeah.
So we do have a pie-shaped lot, so we're 30 feet narrower in the front than we are in the back, so that's part of the problem. And then, for us to have enough turnaround space to park 2 cars, Mims's car and his wife's car, we need that extra space in the back so we can just get in and out and keep our cars off the street. And that's the primary reason. But, and 2, we took a little more area, because one of the things they came to us was they wanted a 1-story house so that they could mature in that house and get around easily. And so by doing that, it takes more square footage on the main level than if we were to put 2 bedrooms upstairs. So it just spread out a little more.
Can
And
I add
believe
something
me,
to that
really-
real quick?
Sure.
Yeah. Now, I wasn't aware that their plan was to have this single-story house. Around the country, this trend is an aging-in-place housing. Typically, these houses are built so that they can easily accommodate needs later on, wider doors. And generally, all of the common areas have to have, you know, a wider door, like the master bathroom and the master bedroom, and then the common areas. And it's not uncommon to need a variance for these types of houses, simply because you are trying to put everything on one level without stairs. And I just wanted to throw that in there, that I wasn't aware of that when I wrote the report, or I would have included that information.
And I think part of the issue comes down, and I appreciate that, that you've shared with us that the variance only applies to or is being requested for discrete parts, the kitchen part in the front, and then the garage in the back.
Right.
I guess maybe if you could give us a little bit more, give us some help to understand why that additional 3 feet is needed in both areas. I think you've already touched a little bit on the garage and the need to fit 2 cars in, but if you can give us a little bit, because I mean, there's typically on this board, when you're starting with a fresh, a piece of clay that you can do whatever you can with, there's a little bit more scrutiny than when you're dealing with an existing structure and trying to make it work. So, but if you could maybe share with us why the bump out on the kitchen is needed and the bump out on the garage.
Can I add on to that real quick? I think it might be helpful if you kind of walk through what some of these rooms are, a common room for that size, a common dimension for a garage, the way that you have your corridor down the middle. You don't want to cant it in one way with the pie shape. I mean, I see kind of the practical nature of the floor plan. I think it would just help everybody if you kind of walked them through how you went about laying out the floor plan and why the pie-shaped lot is giving you issues in those few areas.
Okay. Starting in the back, here in the, in this corner, this is going to be a laundry room in the upper left-hand corner. I'll go down one side and then go down the other side. Is that what you want?
The intent wasn't to go through all the rooms, but just
Okay.
to kind of set the width dimensions, if you will. I think, we remember you from last month.
Right.
And,
Yep.
was that your house as well?
Oh, yeah.
That was the same house, yes.
So this is the same house?
Oh, same house,
yes.
yeah.
I don't think we harped on it that it was one story enough, and I think, maybe we brushed over that. And then, I think it just helps to kind of walk everybody through where the pinch points are, if you will, so that you can kind of tie that back to the shape of the lot.
Sure. Okay, so, one thing is it's important for us all to have quality outdoor space. So that was the covered loggia on the front, which faced the street. And then the front door is directly in front of you as you enter the loggia. And then that's a hallway or a gallery space or whatever you call it. It's a hall basically from the front to the back, wide enough. That is 6 feet wide so that they can comfortably, if they're in wheelchairs or whatever, go directly down that corridor and easily turn left or right into the rooms that they need to go into. As you enter the front door, which I know you guys probably don't, that would be the front door there, okay? So, and that's the corridor here. This is their living room or living space, dining and living in this open area, and then this is the kitchen area right there. It was just a combination of having them to have a door wide enough to get out here to the covered loggia area where they could spend time outside, which was directly off the kitchen. And it really was just about trying to make quality space. by the time we sort of crept with all of our dimensions, this is where we landed. This is, if I'm not mistaken, I think our interior is about 24 feet on the loggia, but if you put a dining table out there and a couple of chairs, it consumes all the space. Our living room is kind of dining room is kind of a standard width, like 16 feet, which is, pretty standard for most. And then the rest of these are in the back, 3 bedrooms, and then a study off the master bedroom here. And that's pretty much how it unfolded. That's really the best explanation I can give you.
Can I hand these out to you? This is another photograph?
Sure.
Okay.
All right, thank you. As I recall from last meeting and having done the minutes, you made reference to the fact that the existing driveway was actually 2 feet over on the other side, and so that the new driveway was having to be pushed back onto the subject property, and that the decision to make it over there was easier access, that it graded towards the left-hand side. And so that's part of the reason, as I understood from last month, you were saying that the house was having to be shifted just a little bit more to the left, and that puts it closer into contact with that left property line. So that was a factor you had mentioned last time that committee members may recall as well.
Yes, sir.
To accommodate the driveway.
Right.
Yes, sir.
Yeah.
This photograph here, you see where I've folded this page? If you unfold the page out, the tall red line is the 3-foot setback. So if you fold the page to that 3-foot setback, the house almost becomes a shotgun house because we pulled it in and it doesn't fit the lot now. It's too narrow for the lot. But you look at it like this, if we were, gonna leave up one wall, we may not be having this hearing, but we can't leave up the wall. So even though we're asking for a 3-foot setback, in my mind, I'm asking to go 14 inches over the existing wall. Does that make sense? I'm asking for 14 inches over the existing wall. And that 14 inches is moving towards my White House, where I live now. And that 14 inches would be 14 inches by 13 feet long. And once you get past that 13 feet, then the setback goes to 13 feet. And the setback goes not from 10, but goes to 13 feet until you go all the way back, and then you go to the garage again, and then the garage will face the other garage. The last thing I want to do is to do anything to downgrade my current property at 308 LaPlaya Place, the White House, or build a house here that doesn't work between the two homes. I've thought long and hard about it, so that's kind of where we are on it. Unfortunately, I can't move the house towards the driveway. We tried that, but we just can't. We're stuck on the other side. So, we're having to work between my existing home and the current home. So, which, like I say, it's 14 inches in that small little kitchen area over the existing wall. So, but when you fold that back, the house just looks too small for the lot.
And there was another, the front of our house has to be set back to be in line with the other houses. So that being said too, we just barely had enough room on the back setback for our one-car garage, which is about 13 feet wide, which really is about as small as we can get for a one-car garage.
Any other questions from the board?
A second.
All right. Mr. Wortley,
Yes.
Mr. Alsabrook,
Yes.
Mr. Perkel,
Yes.
Mr. Gear,
Yes.
and Mr. Roberts.
Yes, so your case passes 5-0. We have 180 days before you.
Thank you very much.
Again, thanks for your patience. I know it's a long time to sit there.
Now that's over, I was asked for more, but I better not.
We're gonna leave now.
Okay. Yeah,
Do what?
exactly.
That's the plan, moving to the new house, yeah. Really, this sounds crazy, but the reason that we're doing this is like Paul said, I cared for my parents, I cared for my wife's parents, and I cared for the lady that lived in this house for 12 years, Mrs. Hasty. And she finally had to go to a nursing home. And caring for all these folks, I thought, you know what? At $10,000 a month at St. Martin's, why don't we build a house that, like Paul said, is old folks ready, which means, you know, no stairs, one level, wide doors that looks good, in the garage, and maybe we can live in this house for, you know, a couple of years longer before we possibly have to go to a nursing home. So that was one reason for building this house. And the second reason for building this house is if I stayed in that White House, I know that if this piece of property sold, that next door is going to be a two-story house with a parking pad in the front. And the neighbor on the other side is like, Mims, please don't sell this house and let some monster two-story house be built and stare down on my pool all the time. And I said, you know, I'm gonna probably buy the house, you know, buy it and tear it down and make a one-story house, 3-bedroom, 2-bath. And even when I got Paul to look at it, he said, you're building a one-story house, really? And I said, yeah, so.
But it is, I mean, it really is a, I lived in Madison, and there was a subdivision that was gonna be, they didn't want the whole thing to be an HEB subdivision, but they
Right.
had certain lots, and, those lots, they, very specifically,
All right. I guess we're still officially on the record, so I'm going to ask for a motion to adjourn. Okay. All right, all in favor?
Aye.
All right.
All right.
And I officially resign as pro tem chair of the BZA.